So we talk about property. We go on and we need to talk about intellectual property and how important that really is to our system and to entrepreneurship, to drug companies, to inventors, to on and on and on. There's lots of reasons for this to be very important. So it includes the application, right? We're going to talk about trade secrets, patents, trademarks, and copyrights. So why do we do it? Well, more productivity of new resources. Imagine if, especially in today's day and age, let's say you went and developed a new drug that cured a form of cancer, or at least was an excellent treatment, and we're seeing more and more of those hit the market, right? But drugs are easily, with today's technology, they're easily reverse engineered, so you might spend billions of dollars developing the drug, and if we didn't have any patent protection, then 2 days afterwards another company could reverse engineer it, and the drug itself might be relatively inexpensive to make, and your billions of dollars of research then would simply go down the drain. And so there has to be that incentive, right, for companies and drugs are just one example. There'd be other industries where, of course, that would be it would count as well. And that provides a lot of incentive then, when you get those protections through a patent. And that's just one example, but it'd be the same for copyright. How difficult would it be for you or I to draw or use pictures of Mickey Mouse? Not difficult at all. But Disney then, again, they've developed that. They've spent a lot of time and effort and put a lot of money into that. They deserve to reap some of those rewards. Or a book, if you were to write a book. It's simple. And digitally to reproduce that would be simple. Okay? But then what incentive would any author have to write a book if that were the case? So we want those incentives to be there. It creates, again, the incentive causes people to work harder, et cetera, et cetera. It's in the Constitution, right, to promote the sciences and the arts. We get faster and we get more R&D because we have these protections, right? And you do give folks a competitive advantage. There's some argument, don't get me wrong. I give you the drug example up there, and there's lots of, if that drug will help or maybe cure a certain type of cancer or even be some benefit. Don't we want to just produce that then for nothing and get it to as many people as possible? Well, the answer is yes, but. Okay, yes, but. If you force the company to do that without them incurring any profit, then the next company, the next wonder drug is not going to be forthcoming. There just won't be that incentive to do it. So business assets, and we've talked about tangible, right, physical assets, and non-tangible, which is, those knowledge-based resources. So really our copyrights and our trademarks and those things are all going to be the intangible type, right? So trade secrets. Although McDonald's just came out with their earnings today, and they were fabulous. So I can't imagine Ronald trying to steal any trade secrets from Burger King. So what are they? Knowledge or information. The Coca-Cola secret recipe, right? It's kept secret. Reasonable measures, and I think they always said that there was 3 components to the Coca-Cola recipe, and they kept them with 3 different executives locked in 3 different safes with 3 different combinations that only, basically those individuals knew, so that no one person would know. But there was a time here, this few years back, it was kind of interesting. We talked about it a lot in law class. Were some folks in the Coca-Cola company that apparently found themselves in possession of the Coke recipe, the recipe for Coke. So it must not have been guarded as closely as they thought. And they actually called up Pepsi, and they offered to share it with Pepsi for money, of course. Pepsi took the high road. It was really interesting. It was very high profile. They not only refused, they turned the folks in and had them arrested for, violating, giving up or exposing something with economic value to another company, which was very illegal. Okay, and I don't recall what the penalties were that they incurred. My guess is probably not a ton of jail time or anything like that, but I'm sure that they were they probably pled guilty to some charges and probably did either spend some jail time or at least some probation and whatnot. So, do we think of other trade secret things? The Colonel secret recipe of 11 herbs and spices and different things like that, right? So to protect trade secrets, businesses have to take reasonable measures to keep them secret. Have to audit, right? They have to identify what those resources are. A lot of the high-tech firms now, it's the algorithms and the codes that they write and those types of things that I don't know a heck of a lot about, right? Locking formulas, right? Protective firewalls for those types of things. Think about the Equifax's breach here recently. Wow. They have to regulate visitor access if there's something that visitors can come in and see, and they might be able to, take pictures of or do those types of things. Okay. So employees, businesses have to take reasonable measures to protect trade secrets from employees, and maybe that's a misnomer, but because employees are obviously, some of them are going to have access to those trade secrets. So what you do then, though, is you have them sign agreements that if they leave the company, they won't share those trade secrets. And there's been some fairly high-profile lawsuits. There was a Mark Hurd who had worked for HP, I believe it was, Hewlett-Packard, back when HP was just one company instead of two now. And I believe, things kind of fell apart there, and he went to work for Oracle. And I'm not so sure that HP didn't sue Oracle when that happened. And I don't remember what the resolution was. My guess is it kind of got settled and went away, and so we haven't heard much about it. But that's what they would sign, right, as a confidentiality or a non-compete agreement. And again, there has to be a valid business purpose. So the business can claim a trade secret only if the knowledge has some economic value, but it doesn't have to be great economic value. Okay, we don't have to prove that it's millions or gazillions of dollars, just that there's some value to that information. It can overlap, meaning that the information that you have might overlap with information that others have. Go back to used Equifax, but there's three main credit reporting agencies: there's TransUnion, Equifax, and Experian, and your name probably appears on all three. Okay, and most of your credit information probably appears on all three, so it's overlapping, but it's still secrets that each of those companies have individually, that information. It has some value, obviously, and it does overlap with other companies, but that doesn't mean that it's still not a trade secret. So there can be both civil and criminal enforcement. Remember I told you about the Pepsi and the Coke, and Coca-Cola certainly could have sued those folks. My guess is they let the criminal part of it go, and perhaps they didn't pursue any civil charges, and probably because Pepsi turned them in, so there wasn't any harm that ended up being done. So they might have had a difficult time recouping, any money anyways. But there can be injunctions to prevent the use or divulging of. And I know in an example that I gave you with HP and Mark Hurd, I believe that they did in fact issue an injunction. A judge did. Not that Oracle couldn't hire him or whatever, but just simply, if I remember right, saying that Mark Hurd was prohibited from divulging any of that information that he had left HP with. It could delay in taking a job. Okay, there could be damages. Okay, again, if it's civil, possibly criminal as well. And there is an Economic Espionage Act that talks about those things, and the rules and regulations about sharing inappropriately that type of information. So let's stop there, and we'll come back and do the rest in some other parts. So